I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
One to 10947. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a FREDA hearing.
It is FREDA. Mr. Allegretti wants to represent himself. So did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Allegretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No, I
you will
cannot
have
finish
counsel.
talking.
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that, Your Honor.
You are accepting it, sir. You know what direct contempt of
I
court
wanted
is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record. You understand that, sir?
Yes.
What's your address?
7021 Square, Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear, I struck your frivolous proceedings from the record a few days ago. Officer Ball, can you give him this? Sure. In that, I wanted to make sure that you were explicitly warned that, well, firstly, I'll consider this conduct during the FREDA hearing as evidence of an inability or unwillingness to abide by the rules of procedure, which may result in the denial of your request to represent yourself, which I have already done. Okay, so I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time your lawyer's filing things, because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand the words I used or what they mean?
Everything.
What's your level of education, sir?
I have some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer though,
I just appointed a lawyer for you.
but I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sure, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay, so I have time that I work on cases. Everything's pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your Honor,
why?
but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in equity, Your
you're
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter.
Okay, let's go through the charges again. I had an initial hearing with you. Let me see when I had the initial hearing. Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all three charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. Do you not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28th, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be, September 28th of 2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you
Why are
until
you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah,
I'm just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah,
I'm required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand
want-
you
I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No. I already appointed a court-appointed attorney for you because you can't get through the Feretta hearing. You understand why you can't get through the Feretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in propria persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear. Because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. You understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body and I'm a living human
What does
being.
it mean, sir?
Are you here to practice court? I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
And
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
What's your statement?
Why is that so hard to?
Because the first part of your statement, this is a Feretta hearing. I'm here for a Feretta hearing. I've already denied your Feretta rights based on the very first words that came out of your mouth, which was that you're not willing to subject yourself to the jurisdiction of the court. If you're not willing to subject yourself to the jurisdiction of the court, you're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. So I've appointed counsel for you. I was going through the charges in count one, but I needed to find something here. I took some notes the other day related to your case, and I wanted to make sure that we had that as well. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me what do you not understand.
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Allegretti, is find that you've unduly delayed these proceedings.
All I want to
Find you in direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor, I
contempt.
have a job.
Please take Mr. Allegretti into custody. We'll try again tomorrow, sir. We'll be adjourned in F210947, and I'll open a new case on the contempt proceeding as required by rule.